RA 716, a Local Governance Code of 1991, Republic Act. Prepared by BPA to Section 4.
Good morning, ma'am. Good morning, everyone. I'm going to report about the Local Government Code of the Philippines. Book 1, General Provisions, Title 1, Basic Principles, Chapter 1, the Code, Policy, and Application. Section 1, Title. This act shall be known and cited as the Local Government Code of 1991. Section 2, Declaration of Policy. It is hereby declared the policy of the state that the territorial and political subdivision of the state shall enjoy genuine and meaningful local autonomy to enable them to attain fullest development as self-reliant communities and make them more effective partners in the attainment of national goals. Section 3, Operative Principle of Decentralization. The formulation and implementation of policies and measures on local autonomy shall be guided by the following operative principle. There shall be an effective allocation among the different local government units of the respective powers, functions, responsibility, and resources. Section 4, Scope of Application. This code shall apply to all provinces, cities, municipalities, barangay, and other political subdivisions as may be created by law and to the extent herein provided. The officials, offices, or agencies of the national government. Section 5, Rules of Interpretation. In the interpretation of the provision of this code, the following rules shall apply. In its power and in case of doubt, and questions thereon shall be resolved in of devolution of powers and of the local government unit. And Chapter 2, General Powers and Attributes of Local Government Unit. Section 6, Authority to create local government units. A local government unit may be created, divided, merged, abolished, or its boundaries substantially altered either by law enacted by Congress in the case of province, city, municipality, or any other political subdivision, or by ordinance passed by the Sangguniang Panlalawigan or Sangguniang Panglungsod, concerned in the case of a barangay located within its territorial jurisdiction, subject to such limitations and requirements prescribed in this code. Section 7, Creation and Conversion. As a general rule, the creation of a local government unit or its conversion from one level to another level shall be based on verifiable indicators of viability and projected capacity to provide services. Section 8, Division and Merger. Division and merger of existing local government units shall comply the same requirements herein prescribed for their creation, provided, however, that such division shall not reduce the income, population, or land area of local government unit or units concerned to less than minimum requirements prescribed in this code, provided further that the income classification of the original local government unit or unit shall not fall below its correct income classification prior to such division.
This is the continuation of Chapter 2, General Powers and Attributes of Local Government Units. Section 9, Abolition of Local Government Units. A local government unit may be abolished when its income, population, or land area has been irreversibly reduced to less than the minimum standards prescribed for its creation under Book 3 of this Code, as certified by the national agencies mentioned in Section 17 hereof to Congress or to the sanggunian concerned, as the case may be. Section 10, Plebiscite Requirements. No creation, division, merger, abolition, or substantial alteration of the boundaries of the local government unit shall take effect unless approved by a majority of the votes cast in a plebiscite called for the purpose in the political unit or units directly affected. Section 11. Selection and transfer of local government sites, offices, and facilities. The law or ordinance creating or merging local government units shall specify the seat of government from where governmental and corporate services shall be delivered. When conditions and developments in the local government unit concerned have significantly changed subsequent to the establishment of the seat of government, its sanggunian may, after public hearing and by a vote of 2/3 of all its members, transfer the same to site better suited to its needs. Local government offices and facilities shall not be transferred, relocated, or converted to the other uses unless public hearings are first conducted for the purpose and the concurrence of the majority of all the members of the sanggunian concerned is obtained. Section 12. Government Centers. Provinces, cities, and municipalities shall endeavor to establish a government center where offices, agencies, or branches of the national government, local government units, or government-owned or controlled corporation may, as far as practicable, to be located. In designating such a center, the local government unit concerned shall take into account the existing facilities of national and local agencies and offices which may serve as government center and shall bear the expenses for the construction of its building and facilities in the government center. Section 13. Naming of local government units and public places, streets, and structures. The Sangguniang Panlalawigan may, in consultation with the Philippine Historical Commission or PHC, the Sanggunian of highly urbanized cities and component cities whose charters prohibit their voters from voting for provincial elective officials, hereinafter referred to in this code as independent component cities, may, in consultation with the Philippine Historical Commission, the Sanggunians of component cities and municipalities may, in consultation with the Philippine Historical Commission. None of the foregoing local government units shall be named after a living person, nor may a change of name be made unless for a justifiable reason, and in any case not oftener than once every 10 years. The name of a local government unit shall not be changed unless by a unanimous vote of the sanggunian concerned and in consultation with the PHC. A change of name of a public school shall be named only upon the recommendation of the local school board concerned. A change of name of public hospitals, health centers, and other health facilities shall be named only upon the recommendation of the local health boards concerned. The change of name of any local government units shall be effective only upon ratification in a plebiscite conducted for the purpose in the political unit directly affected. In any change of name, the office of the President, the representative of the legislative district concerned, and the Bureau of Posts shall be notified. Section 14. Beginning of corporate existence. When a new local government unit is created, its corporate existence shall commence upon the election and qualification of its chief executive and a majority of the members of its sanggunian, unless some other time is fixed therefor by the law or ordinance creating it. Section 15. Political and corporate nature of local government units. Every local government unit created or recognized under this code is a body politic and corporate endowed with powers to be exercised by it in conformity with law. As such, it shall exercise powers as a political subdivision of the national government and as a corporate entity representing the inhabitants of its territory. Section 16. General Welfare. Every local government unit shall exercise the powers expressly granted, those necessarily implied therefrom, as well as powers necessary, appropriate, or incidental for its efficient and effective governance, and those which are essential to the promotion of the general welfare.
Section 17. The basic services and facilities. Such as basic services and facilities for barangays include but are not limited to the following. These are the basic examples of basic service and facilities: health service, support education, social welfare, the governance and response, public works and infrastructure, environmental management, economic and investment promotion. For the municipal, we have here the public market, public toilet, public cemetery, municipal buildings. Section 17. Basic services and facilities. Local government units shall endeavor to the self-reliance and shall continue exercising the power and discharging the duties and functions currently vested upon them. They shall also discharge the functions and responsibilities of national agencies and offices devolved to them pursuant to this code. Local government units shall likewise exercise such other powers and discharge such other functions and responsibilities such as necessary, appropriate, or incidental to efficient and effective provision of the basic service and facilities enumerated. Such basic services and facilities include but are not limited to the following. For barangay, we have here the agricultural support services, which includes the planting materials, distribution system, and operation of farm produce, collection, and buying stations. We also have here the health and social welfare services, which includes maintenance of barangay health center and daycare center. And also we have the services and facilities related to the general hygiene and sanitation, beautification, and solid waste. Section 18. Power to generate and apply resources. Local government units shall have the power and authority to establish an organization that shall be responsible for the efficient and effective implementation of their own development plans, programs, objectives, and priorities. Section 19. Eminent domain. A local government unit may, through its chief executive and acting pursuant to an ordinance, exercise the power to eminent domain for the public use or purpose or welfare for the benefit of the poor and the landless. Upon payment of just compensation, power of eminent domain may not be exercised unless a valid and denied offer has been previously made to the owner. Section 20. Reclassification of lands. A city or municipality may, through an ordinance passed by the Sanggunian after conducting public hearings for the purpose, authorize the reclassification of agricultural lands and provide for the manner of their utilization or disposition in the following case. When he land the cases to be economically feasible and sound for agricultural purposes, as determined by the Department of Agriculture, or where the land shall have substantially greater economic value for the residential, commercial, or industrial purpose, as determined by the Sanggunian concerned, provided that such reclassification shall be limited to the following percentage of the local and agricultural land areas at the time that the passage of the ordinance. Section 21. Closure and opening of roads. A local government unit may, pursuant to ordinance, permanently or temporarily close or open any local road, alley, park, or square falling within its jurisdiction, provided, however, that in case of permanent closure, such ordinance must be approved by the least 2/3 of all members of the Sanggunian, and when necessary, an adequate substitute for the public facility that is subject to closure is provided. But no such way or place or any part of thereof shall be permanently closed without making provisions for the maintenance of public safety therein. A property thus permanently withdraw the public use may be used or conveyed for any purpose for which other real property belongings to the local government unit concerned may be lawful use or convey. Any national or local road, alley, park, or square may be temporarily closed during an actual emergency or fiesta celebration, public rallies, agricultural or industrial fairs, or an undertaking of public works and highways, telecommunication, and waterworks projects, the duration of which shall be specified by the local chief executive concerned in written order, provided, however, that no national or local road, alley, park, or square shall be set temporarily closed for athletic, cultural, or civic activities not officially sponsored, recognized, or approved by the local government. Section 23. Authority to negotiate and secure grants. Local chief executive may, upon authority of the Sanggunian, negotiate and secure financial grants or donations in kind in support of the basic services and facilities enumerated under the Section 17 hereof from the local and foreign assistance agencies without necessary of securing clearance or approval. Therefore, from any department, agencies, or office, the national government, or from any higher local government unit, provided that a project financed by such grants or assistance with national security implementation shall be approved by the national agency concerned, provided further that when such national agencies fails to act, the request for approval within 30 days from the receipt, therefore, the same shall be the Section 24. Liability for damages. Local government units and their officials are not exempt from liability for death or injured to the persons or damage of property.
Chapter 3 Intergovernmental Relations. Section 25 National Supervision of Local Government Units. Section 26 Duty of Governmental Agencies in the Maintenance of Ecological Balance. Section 27 Prior Consultations Required. Section 20A Power of Local Chief Executive over the units of Philippine National Police. Section 29 Provincial Relations with Component Cities and Municipalities. Section 30 Review of Executive Orders. Section 31 Submission of Municipal Question to the Provincial Legal Officer or Prosecutor. Section 32 City and Municipal Supervision over their respective barangays.
Good day, ma'am. My name is Angelica de la Cruz. The topic is all about the Local Government Code of the Philippines, Book 1, General Prevention, Title 1, Basic Principle. And I am going to report Section 33 to Section 40. First, cooperative undertaking among local government units. Local government units may thought appropriate ordinance group themselves consolidate or coordinate their efforts, service, and resource for purpose commonly beneficial to them in support of such undertaking. The local government's units involved may upon approved by a sangguniang concerned after a public hearing conducted for the purpose contribute funds, real estate, equipment, and other kinds of property, and appoint of assigned personnel under such term and coordinations as may be agreed upon the participating local unit through memoranda of agreement. Chapter 4, Relations with People and Non-Governmental Organization. Section 34, Role of People and Non-Governmental Organization. Local government units shall promote the establishment and operation of people and non-governmental organizations to become active partners in the pursuit of local autonomy. Section 35, Linkage with people and non-governmental organizations. Local governments units may enter into joint ventures and such other cooperative arrangement with peoples and non-governmental organizations to engage in the delivery of certain basic service, capability building, and livelihood projects, and to develop local enterprise designed to improve productivity and income diversity, agriculture, spur rural industrialization, promote ecological balance, and enhance the economic and social well-being of the people. Section 36, in assistance of people and non-governmental organization. A local government unit may through its local chief executive and with the concurrence of the sangguniang concerned provide assistance, financial or otherwise, to such people and non-governmental organization for economic, social-oriented, environmental, or cultural project to be implemented with its territorial jurisdiction. Chapter 5, the local prequalification, beds, and award committee. Section 37, local prequalification beds and awards committee or local BPEC. There is a heavily create a local pre-qualification beds and awards committee in every province, city, and municipality, which shall be primarily responsible for the conduct of pre-qualification of contractors, bidding, evaluation of beds, and the recommendation of award in concern local and structure project. The chairman of the appropriation committee of sangguniang concern, a representative of the mandatory party and sangguniang concern, if any, or if there be none, one chosen by said sangguniang for among its member. The local treasurer, two representatives of non-government organizations that are represented in local government council concerned to be chosen by the organization themselves, and 11 any practicing certified public accountant. representative of Commission on Audit shall observe the proceedings of such committee and shall certify that the rules and procedure for pre-qualification bids and award have been complied with. First, the agenda and other information relevant to the meeting of such committee shall be deliberated upon by committee of less 1 week before the holding of such meeting. All meeting of the committee shall be held in provincial capital or the city of municipal hall. The minutes of such meeting of the committee and any decision made there is shall be duly recorded, posted, or a prominent place in the provincial capital or the city of municipal hall. Section 38, Local Technical Committee. There is a heavily created a local technical committee in every province, city, and municipality to provide technical assistance to the local pre-qualification bids and award committee. It shall be composed of the following: provincial, city, or municipal engineer, the local planning and development coordinator, and such other official designated by local pre-qualification bids and awards committee. The chairman of the local technical committee shall be designated by the local pre-qualification bids, designated by the local pre-qualification bids award committee. They shall attend meeting in order present and reports and recommendation of local technical community. Next, the Title 2, the elective official. Chapter 1, the qualification and election. Section 39, qualification. First, if you qualify, is an elective local official must be citizen of the Philippines, registered voters, or in the municipality or province or any case of member in Sangguniang Panlalawigan, Sangguniang Panglungsod, or Sangguniang Bayan, the district there is he intend to be elected, resident therein at least 1 year, and able to read to write. Candidates for the position of government vice governor or a member of Sangguniang Panlalawigan, or mayor, vice mayor, or a member of Sangguniang Panlungsod o highly emphasized citizen must be at least 23 years old of age on election day. Candidates for position of mayor or vice mayor, candidates for position of member of Sangguniang Panglungsod or Sangguniang Bayan must be at least 18 years old. Candidate for position of punong barangay or member of Sangguniang Barangay most less 18 years of age. Candidates for Sangguniang Kabataan must be at least 15 years old or more than 21 years old. And then the section 40 is the disqualification. The following persons are disqualified from running for any elective local position. First is those sentenced by final judgment or an offense involved moral turpitude or for an offense punishable by 1 year or more. Those removed from office as a result of an administrative case. So, may mga case. Next, those convicted by final judgment for violating the allegiance of the Republic. Those with dual citizen, muna siyang disqualified. Forgiveness from justice in criminal, permanent resident in a foreign country, or those who have acquired the right reside abroad and continue to avail of same right after the effectively of this code. And the last is the insane of feeble-minded. And that's all the section 33 to section 40. Thank you.
Section 41 to 48. Chapter 1. Qualification and Election. Section 1. Manner of Election. Manner of election: the governor, vice governor, city vice mayor, municipal mayor, municipal vice mayor, and punong barangay shall be elected at large in their respective units by the qualified voters therein. However, the Sangguniang Kabataan chairman for each barangay shall be elected by the registered voters of the for each barangay shall be elected by the registered voters of the Katipunan ng Kabataan as provided in this code. Section 42. Date of election. Unless otherwise provided by law, the election for local officials shall be held every 3 years on the second Monday of May. Section 43. Term of office. The term of office of all local elective officials elected after the effectivity of this code shall be 3 years starting from noon of June 3, 1992, or such date as may be provided for by law, except that of elective barangay officials, provided that all local officials first elected during the local election immediately following the ratification of the 1987 Constitution shall serve until noon of June 30, 1992. The term of office of barangay officials and members of the Sangguniang Kabataan shall be for 3 years, which shall begin after the regular election of barangay officials on the second Monday of May 1994. Chapter 2. Vacancies and Succession. Section 44. If a permanent vacancy occurs in the office of punong barangay, the highest ranking sangguniang barangay member, or, in case of his permanent inability, the second highest ranking sangguniang member shall become the punong barangay. A tie between or among the highest ranking sanggunian member shall be resolved by drawing of lots. The successors, as defined herein, shall serve only the unexpired terms of their predecessors. For purposes of this chapter, a permanent vacancy arises when elective local officials fills a higher vacant office, refuses to assume office, fails to qualify, dies, is removed from office, voluntarily resigns, or is otherwise permanently incapacitated to discharge the function of his office. Section 45. Permanent vacancies in the Sanggunian. Permanent vacancies in the Sanggunian where automatic successions provided above do not apply shall be filled by appointment in the following manner. Except for the Sangguniang Barangay, only the nominee of the political party under which the Sanggunian member concerned had been elected and whose elevation to the position next higher in rank created the last vacancy in the Sanggunian shall be appointed in the manner herein above provided. Section 46. Temporary vacancy in the office of the local chief executive. When the governor, city or municipal mayor or punong barangay is temporarily incapacitated to perform his duties for physical or legal seasons, such as, but not limited to, leave of absence, travel abroad, and suspension from office. The vice governor, city or municipal vice mayor, or the highest ranking sangguniang barangay member shall automatically exercise the powers and perform the duties and function of the local chief executive concerned, except the power to appoint, suspend, or dismiss employees, which can only be exercised if the period of temporary incapacity exceeds 30 working days. Section 47. Approval of leaves of absence. Leaves of absence of local elective officials shall be approved as follows. Leaves of absence of a vice governor or a city or municipal vice mayor shall be approved by the local chief executive concerned, provided that the leave of absence of the members of the sanggunian and its employees shall be approved by the vice governor or city or municipal vice mayor concerned. Chapter 3. Local Legislation. Section 48 and the last. Local legislative power. Local legislative power shall be exercised by the sangguniang panlalawigan for the province, the sangguniang panglungsod for the city, the sangguniang bayan for the municipality, and the sangguniang barangay for the barangay. And that's all. Thank you.
In Book 1, Chapter 3, it is about the local legislation. So in Section 49, Presiding Officer, the Vice Governor shall be the President Officer of the Sangguniang Panlalawigan. In the event of the inability of the regular Presiding Officer to President at the Sangguniang session. In Section 15, it talks about the internal rules of procedure. So the rules of procedure shall provide the legislation or the legislative process. And Section 51, it is about the full disclosure of financial and businesses interests of sangguniang members. Every sangguniang members shall upon assumption to office. So Section 52, it is about the session. On the first day of the session, immediately the following the election of its member, the sanggunian shall be resolution fix the day, time, and place of its regular session. So, Section 53, it talks about the quorum. Majority of all members of the sanggunian who have been elected and qualified shall be constituted a quorum to transact official businesses. And the Section 54, it is the approval of ordinances. Ordinances enacted by the Sangguniang Panlalawigan, Sangguniang Panglungsod, and Sangguniang Bayan. The veto shall be communicated by the local chief executive concerned to the Sanggunian with 15 days in the case of province and the 10 days in the case of the city or the municipality. And Section 55, the veto power of the local chief executive. And Section 56, it is about the review of the component city and the municipality ordinances or resolution by the Sangguniang Panlalawigan.
Section 58. Enforcement of disapproved ordinance or resolutions. Any attempt to enforce any ordinance or any resolution approving the local development plan and public investment program after the disapproval thereof shall be sufficient ground for the suspension or dismissal of the official or employee concerned. Section 59. Effectivity or ordinances or resolution. Unless otherwise stated in the ordinance or the resolution approving the local development plan and public investment program, the same shall take effect after 10 days from the date a copy thereof is posted in a bulletin board at the entrance of the provincial capital or city, municipal or barangay hall, as the case may be, and it at least 2 or other conspicuous places in the local government unit concerned. Chapter 4, Disciplinary Action. Section 60. Grounds for disciplinary action. An elective local official may be disciplined, suspended, or removed from office on any of the following grounds: disloyal to the Republic of the Philippines. Section 57. Review of barangay ordinances by the Sangguniang Panglungsod or Sangguniang Bayan. Within 10 days after its enactment, the Sangguniang Barangay shall furnish copies of all barangay ordinances to the Sangguniang Panglungsod or Sangguniang Bayan, concerned for review as to whether the ordinance is consistent with the law and city municipal ordinances. If the Sangguniang Panglungsod or Sangguniang Bayan, as the case may be, fails to take action on barangay ordinances within 30 days from receipt thereof, the same shall be deemed approved. If the Sangguniang Panglungsod or Sangguniang Bayan, as the case may be, finds the barangay ordinances inconsistent with law or city municipal ordinances, the Sangguniang concerned shall, within 30 days from receipt thereof, return the same with its comments and recommendations to the Sangguniang Barangay concerned for adjustment, amendment, or modification, in which case the effectivity of the barangay ordinance is suspended until such time as the revision called for its effected. Culpable violation of the Constitution, dishonesty, oppression, misconduct in office, gross negligence, or dereliction of duty, commission of any offense involving moral turpitude, or an offense punishable by at least prison mayor, abuse of authority, unauthorized absence for 15 consecutive working days, except in the case of members of the Sangguniang Panglalawigan, Sangguniang Panglungsod, Sangguniang Bayan, and Sangguniang Barangay. Section 61. Form and filing of administrative compliance. A verified complaint against any erring local elective official shall be prepared as follows. A complaint against any elective official or of a province, a highly urbanized city, an independent component city, or component city shall be filed before the office of the President. Section 2. Notice of hearing. Within 7 days after the administrative complaint is filed, the office of the President or Sangguniang concerned as the case may be shall require the respondent to submit his verified answer within 15 days from receipt thereof, and commence the investigation of the case within 10 days
Good day, ma'am. For today's report, I will discuss section 73 to section 83. First, we have section 73, prohibition for resignation. The elected local officials sought to be recalled shall not be allowed to resign while the recall process is in progress. And then, section 74, limitation on call. Any elected local official may be the subject of a recall election only once during his term of office for loss of confidence. No recall shall take place without one year from the date of official's assumption to office or 1 year immediate preceding a regular local election. And then section 75, expense incident to recall election. All expenses incident to recall election shall be borne by the Comelec. For these purposes, there shall be included in the annual general. First, appropriates act of contingency fund at the disposal of COMELEC for the conduct of recall election. The third one is the Title 3, the Human Resource and Development. In Section 73, Organization Structure and Staffing Pattern, every local government unit shall design and implement its own organization structure and staffing pattern, taking into consideration its service requirements and financial capability subject to the minimum standards and guidelines prescribed by the Civil Service Commission. And then section 76, it is a responsibility for human resource and development. The chief executive of every local government unit shall be responsible in for human resource and develop in his unit and shall take all personnel actions in accordance with the constitutional provision on civil service, pertinent laws and rules and regulation thereon, including such politics, guidelines, and standard as the Civil Service Commission may establish, provide that the local chief executive may employ emergency or casual employees or laborers paid on a daily wage of piecework basis that hired through job orders for local project authorized by Sangguniang concerned without need of approval or accession by Civil Service Commission. Also provide further that the period of employee of emergency of cause laborer as provided in his section shall not exceed or 6 months. The Joint Commission on Local Government Personnel Administration, organized pursuant to Presidential Decree number 1160 or PD number 136, is hereby abolished and its personnel, records, equipment, and other assists transferred to the appropriate office in the Civil Service Commission. Sumoto siya ang Section 77. And then, next is Section 78, the Civil Service Law or Rules and Regulation and other related assurance. All matters pertinent to the human resource and development in local government units shall B. Government by civil service, law and such rules and regulation, and other assurance promulgated pursuant thereto, unless otherwise specified in this code. And next is Section 79, the limitation on appointments. No person shall be appointed in the career service of the local government if he or she related within the fourth civil degree of consanguinity of affinity to the appointing or recommending authority. And the last is the Section 80, which is the public notice of vacancies. Personnel selected board. Letter A. Whenever a local chief executive decided to fill vacant career position, there shall be posted notice, so mag-post silang mga notice of the vacancy in the less or 3 conspicuous public place in the local government units consider for a period of not less than 15 days. So, muna siya not less than 15 days. And next, letter B is, there shall be established in every province, city, or municipality a personnel selected board to assist the local chief, executive, and the judicious and objectives selection of personnel for employment as well as for promotions and in formulation of such policies as would contribute to employee welfare. And letter C, the personnel selected board shall be headed by the local chief executive and its member shall be determined by resolution of the sangguniang concerned. A representative of a civil service commission, if any, and the personnel officers of the local governments until concerned shall be ex-office member of a board. So that's all the section 73 to section 8. And I thank you.
Section 81, compensation of local official and employees. That compensation of the local officials and personnel shall be determined by the concern, provided that the increase in compensation of the elected local official shall be take effect only after the term of the official for those approving such increase shall be expired, provided further that the increase in compensation of the approving official employee shall be take effect as provided in the ordinance authorization as increase, provided however that said increase should not exceed the limitation of the budgetary allocations for personal service provided under the Title 5, Book 2 of the Code, provided finally that such compensation may be based upon the provided of the Republic Act numbered 6758, RA number 6758, otherwise known as the Compensation and Position Clarification Act of 1989. Section 2, Resignation of Elective Local Official. Resignation by electing local official shall be effective only upon acceptance of the following authorities. Section 83, Procedure. In every local government unit, the local chief executive shall establish
a procedure to inquire into, act upon, resolve, or settle, comply by, presented by local government employee. Section 84. Administrative discipline, investigation and adjudication of administrative complaint against appointed local official and employees, as well as their suspension and removal, shall be accordance with the Civil Service Law of Rules and other pertinent law. The result of such administrative investigation shall be report to the Civil Service Commissions. Section 85. Preventive suspension of appointed local officials of employees. The local chief executives by preventively suspends of the period of exceeding 60 days any official of employees under his authority. Investigation in the charge against such as official or employee involves dishonest opposition or gives misconduct of the performance of duty, or it's there a reason to believe that the responded. Section 86. Administrative investigation. In any local government unit, administrative investigation may be conducted by the person or communicate duty authorities by the local chief executive. Said person or committee shall conduct hearings or on a case through against appointed local officials and employees, and submit their findings and recommendation of the local chief executive concerned within 15 days from the conclusion of the hearing. The administrative case therein mentioned should be decided within 90 days for the time that respondent is formally notified by the charge. Section 87. Disciplinary jurisdiction expect of the otherwise provided by law of the local chief. Section 88. Executive pending appeal. An appeal shall not provide the executive and of a decision of removal or suspension of the respondent applicant in case the respondent applicant is executed. He shall be his position with all the rights and privilege thereto for the time he has been
This is the local government of the Philippines, Section 89. Prohibited business and pecuniary interest shall be unlawful for any local government official or employee, directly or indirectly. Section 90. Practice of profession. All governors, city, municipal, mayors are prohibited from practicing their profession or engaging in any occupation other than the exercise of their functions as local chief executives. Section 91. Statement of assets and liabilities. Official and employees of local government units shall file sworn statement or assets, liabilities, and network in government service, financial and business interests, and professional data sheets as required by law. Section 92. Oath of office. All elective and appointive local official and employees shall, upon assumption to office, that oath or affirmation of office shall be filed with the office of the local chief executive concerned. The individual personnel records filed under the custody personnel records of the personnel office, division, or section of the local government units concerned. Section 93. Partisan political activity. No local official or employee in the career civil service shall engage directly or indirectly in any partisan political activity or take part of any election, initiative, referendum, plebiscite, or recall. Elective local official may take part in partisan political and electoral activities, but it shall be in the ways of unlawful for them to solicit contribution from their subordinates, the Prohibited Act under the Omnibus Election Code. Section 94. Appointment of elective and appointed local official. Candidates who lost in election. No elective or appointed local official shall be eligible for appointment of designation in any capacity to any public office or position during his tenures. Section 95. Additional or double compensation. No elective or appointive local official or employee shall receive additional double or indirect compensation unless specifically authorized by law. Pension or retention shall not be considered or additional double or indirect compensation. Section 96. Permission to leave station. Provincial, city, municipal, and barangay appointive official going on official travel shall apply and secure with written permission from their official going respective local chief executive before departure. The application shall specify the reason such travel, and the permission shall given or written based on consideration, interest, financial capability of the local government unit concerned, and urgency of the local travel.
Good afternoon, everyone. Today is my report regarding or about the section in the RE 7160. My name is Medyo May Magdadaro, public administration student. Section 4. My report is start for the section 97 until section 104. Section 97 is annual report. The local chief executive must submit an annual report to the Sanggunian and socio-economic, political, and peace and order conditions for the preceding year, covering the preceding calendar of the year. The peace and order condition of the preceding of the year is the Department of Interior and Local Government receives of copy, and component cities and municipalities provide copies. In Section 98, they create the composition and compensation. The Department of Education, Culture, and Sports is responsible for the creation, composition, of compensation of the local school boards in every province, city, or municipality. In Section 99, they have a function of local school boards. The special education fund and supplementary budgetary resource is determined by the Department of Education, Culture, and Sports based on annual needs of public schools. In Section 100, the meetings and quorum. The local school board meets monthly or as needed with a quorum of all members, the superintendent, city superintendent, and district supervisor, prepares to the school board's budget, supported by programs, projects, and activities of the upcoming fiscal year. In Section 101, Compensation and Remuneration, the co-chairman and members of the provincial, city, or municipal school board shall perform their duties as such without compensation or remuneration members. In Section 102, we have also a creation and composition for the Committee on Health of Sangguniang Panglusod, and the Committee of Health of Sangguniang Panlalawigan are responsible for providing health service in the province, city, and municipality. In Section 103, meetings and quorum, budgetary and proposal are prepared and considered as monthly meetings with a quorum of members. The chairman and vice chairman must be present, and the affirmative vote is required for approval. Last is Section 104, Compensation and Remuneration. Members of the Health Board, including non-government officials, are entitled to necessary traveling expenses and allowance chargeable against the local health board's funds, subject to existing accounting and auditing rules. That's all for today, and thank you.
Summary report for the Local Government Code of the Philippines, Section 105 to 112. Section 105, Direct National Supervision and Control by the Secretary of Health. The Secretary of Health may temporarily assume direct supervision and control over health operation in any local government unit for the duration of the emergency. The period for such direct national control and supervision may be extended to 6 months with the concurrence of local government unit concerned. Section 106, Local Development Councils. Each local government unit shall have a comprehensive multi-sectoral development plan. The Development Council at the provincial, city, municipal, or barangay level will assist the corresponding sanggunian in setting the direction of economic and social development. Section 107, Composition of Local Development Councils. The composition of the Local Development Council shall be as follows. The City or Municipal Development Council shall be headed by the Mayor. The Council is composed of the following members: all mayors of component cities and municipalities, the chairman of a committee and appropriations of Sangguniang Panlalawigan, the congressman or his representatives, and representatives from non-governmental organization operating in the province as may be, who shall constitute not less than 1/4 of members of fully organized council. Section 108, Representation of non-governmental organization. Section 109, Function of local development councils. A provincial, city, and municipal development council shall exercise the following function. 1. Formulate long-term, medium, and annual socio-economic development plans and policies. 2. Appraise and prioritize local investment incentives to promote the inflow and direction of private investment capital. 3. Coordinate, monitor, and evaluate the implementation of development programs and projects. 4. Perform such other functions as may be provided by law or competent authority. The Barangay Development Council shall exercise the following functions. 1. Mobilize people's participation in local development efforts. 2. Prepare barangay development plans based on local requirements. 3. Monitor and evaluate the implementation of national or local programs and projects, and perform such another functions as may be provided by law or competent authority. Section 110, Meetings and Quorum. The Local Development Council shall meet at least once every 6 months or as often as may be necessary. Section 111, Executive Committee. Each local development council shall create an executive committee to represent it and act in its behalf when it's not in session. It shall be composed of the governor as chairman, the representative of component city and municipal mayors to be chosen from among themselves, and the chairman of a committee on appropriation of Sangguniang Panlalawigan, president of city or municipal league of barangays as members, and ensure the councils are faithfully carried out and implemented. Act on matters requiring immediate attention. Section 112, Sectoral or Functional Committees. The local development councils may form sectoral or functional committees to assist them in the performance of their functions. A group of committees can be formed to help them with their duties if they are not involved in their activities unless they have the capacity to perform their tasks.
Section 113, Secretariat.
Section 113, Secretariat. There is hereby constitute for its local development council a secretariat which shall be responsible for providing technical support, documentation of proceedings, preparation of reports, and such other assistance as may be required in the discharge of its functions. The local development council may avail of the services of any non-governmental organization or educational or research institution for this purpose.
Section 114, Relation of Local Development Councils to the Sangguniang and Regional Development Councils.
The policies, programs, and projects proposed by local development councils shall be submitted to be Sangguniang concerned for appropriate actions. The local development plans of the next higher level of local development council.
Section 115, Budget Information.
The Department of Budget and Management shall furnish the various local development councils informations on financial resources and budgetary allocations applicable their respective jurisdictions to guide them in their planning function.
Title 7, Local Peace and Order Council. Section 116, Organization.
There is hereby established in every province, city, and municipality a local peace and other council pursuant to Executive Order number 309 AO number 309 series of 1988. The local peace and order councils shall have the same composition and functions as those prescribed by the said executive order.
Title 8, Autonomous Special Economic Zone. Section 117, Establishment of Autonomous Special Economic Zones.
The establishment by law of autonomous special economic zones in selected areas of the country shall be subject to concurrence by the local government units included therein.
Title 9, Other Provisions Applicable to Local Government Units. Chapter 1, Settlement of Boundary Disputes. Section 118, Jurisdictional Responsibility for Settlement of Boundary Dispute.
Boundary dispute between and among local government units shall as much as possible be settled amicably.
Section 19. Appeal.
Within the time and manner prescribed by the rules of court, any party may elevate the decision of the sanggunian concerned to the proper regional trial court having jurisdiction over the area in dispute. Chapter 2, Local Initiative and Referendum.
Section 120. Local initiative defined.
Local initiative is the legal process whereby the registered voters of a local government unit may directly propose, enact, or amend any ordinance.
Good day, everyone. I am Gary Mahawan. My task today is to discuss Chapter 2, Section 121 to 127. This is entitled Local Initiative. The power of local initiative and referendum may be exercised by all registered voters of the province, cities, municipalities, and barangays. In chapter 2, they have in section 122, they have from A to H. They have procedure in local initiative. From A to H, not less than 1,000 registered voters in case of provinces, and 100 in case of cities and municipalities, and 50 in case of barangays may file a petition with the sangguniang concerned processing adoption, enactment, repeal, or amendment of an ordinance. If no favorable action thereon is taken by the sangguniang concerned within 30 days from its presentation, the proponents, through their duly authorized and registered representatives, may invoke their power of initiative, giving notice thereof to the sangguniang concerned. The proposition shall be numbered serially starting from numeral 1. The COMELEC or its designated representative shall extend assistance in the formulation of the proposition. 2 or more propositions may be submitted in an initiative. Proponent shall have 90 days in case of provinces and cities 60 days in case of municipalities, and 30 days in case of barangays from notice mentioned in subsection hereof to collect the required numbers of signatures. The petition shall be signed before the election registrar or his designated representatives in the presence of a representative of the proponent and a representative of the sangguniang concerned in a public place in the local government unit, as the case may be stationed for collecting signatures, may be established in as many places as may be warranted. Upon the lapse of the period herein provided, the COMELEC, through its office in local government units concerned, shall be certified as to whether or not the required number of signature has been obtained. Failure to obtain the required number defeats the proposition. If the required number of signature is obtained, the COMELEC shall then set a date for the initiative during which the proposition shall be submitted to the registered voters in the local government units concerned for the approval within 60 days from the date of certification by the COMELEC, as provided in subsection hereof in case of provinces in case of provinces and cities, 45 days in case of municipalities, and 30 days in case of barangays. The initiative shall then be held on the date set, after which the result thereof shall be certified and proclaimed by the COMELEC. Section 123, we have the local proposition, no, effectively of the local proposition. If the proposition is approved by the majority of the votes cast, it shall take effect 15 days after certification by the COMELEC, as it affirmative action thereon had been made by the sanggunian and local chief executive concerned. If it fails to obtain said number of votes, the proposition is considered defeated. Section 124, no, limitations on local initiative. They have our local initiative, or they have their limitation. The power of local initiative shall not be exercised more than once a year. Initiative shall extend only to subjects or matters which are within the legal powers of the sanggunian to enact. If at any time before the initiative is held, the sanggunian concerned adopt into the proposition presented and the local chief executive approves the same, the initiative shall be cancelled. However, those against such action if they so desire, apply for initiative in the manner herein provided. Section 125, no limit. They have the limitation of the sanggunians, no. If the local initiative is, they have the limitation, they have also the limitation of the sanggunians, no. Any proposition or ordinance approved through the system of initiative and referendum as herein provided shall not be repealed, modified, or amended by the sanggunian concerned within 6 months from the date of the approval thereof, and may be amended or modified or repealed by the sanggunian within 3 years thereafter by a vote of 3/4, no, of all its members, provided that in case of barangays, the period shall be 18 months after the approval. Section 126, the local referendum defined, no. Local referendum is the legal process whereby the registered voters of the legal government units may approve, amend, or reject any ordinance enacted by the sanggunian. Now, the local referendum shall be held under the control and direction of the COMELEC within 60 days in case of provinces and cities, 45 days in case of municipalities, and 30 days in case of barangays. No? The COMELEC shall certify and proclaim the result of the said referendum. Authority of courts. This is the section 127, the authority of the courts. No? Nothing in this chapter shall prevent or preclude the proper courts from declaring null and void any proposition approved pursuant to this chapter for the violation of the Constitution or want of capacity of the sanggunian concerned in to enact the said measures. No, that's all. No, this is Gary Mahawan reporting. Good day.